Gentlemen, and welcome to the Foley's Environmental Law Update web conference series. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session, and instruction will follow at that time. If anyone should require assistance during the conference, please press star and 0 on your touch-tone telephone. As a reminder, this conference call is being recorded. I would now like to introduce your host for today's conference, Mr. Dick Stoll. You may begin your conference.
Okay, thanks very much. Today, we're going to have several people from Foley and Lardner give a presentation on some very recent and very significant Clean Air Act issues. We're going to have Mark Timke, who is a partner in our Milwaukee office, Brian Potts, who's with us in our Madison office, Madison, Wisconsin, and Dottie Watson from Orlando, Florida. I'm in the D.C. office. A few housekeeping things real quickly. There's the phone number to call if you have any problems with live meeting, that 866 number, if you have any problems with live meeting. If you have any problems with your phone, do the *0. It's already been said, we're going to have hopefully a little time for Q&A at the end. You can send in written questions that we'll try to address. If we can't address your written questions during the presentation, we'll endeavor to get back to you with an email afterwards. And again, there'll be a way to call in for questions at the end if we have time, which we often do. You can hit F5 on your keyboard to maximize. There's some instructions there about printing, and also as far as CLE, there's some contact information for Jennifer Bartz. If you have any questions about that, there's her email address, jbartz@foley.com, so you can check on that. And again, remember, this will be on our website after the presentation. A few days after, you can come to our website and get a total repeat of the whole thing, both audio and video. The program today is really going to cover some stuff under the Clean Air Act that's really recent. I think the title of the program had been Recent EPA Rulemaking Developments. There's a couple of judicial developments now that have come up even since we wrote the title of this program. So there's 4 things that have happened just in the last literally 3 or 4 weeks that are pretty doggone significant to wide swaths of industry. We have December 16th, just right before Christmas. We have the final EGU MAC rules, and they're not even in the Federal Register yet, but Mark and Dottie have read them and are going to talk about them in a minute. We have the December 23rd Federal Register, in which EPA reproposed major revisions to the Boiler MAC, SISWI, and RCRA non-hazardous secondary material rules. Then, on December 30th, right before New Year's Eve, the D.C. Circuit issued a stay of the cross-state rule that applies in 27 states to electric utilities. And then just Monday of this week, District Court here in the District of Columbia issued an order that vacated EPA's prior suspension of its Boiler MAC and SISWI rules while it was reconsidering them. We're going to talk about all these things in the next 45 minutes. And to start things out, we'll go to Mark and Dottie on the new Mercury MAC.
Thank you, Dick. And we're going to go through this quickly, as Dick mentioned, and hit the high points. It was an 800-page Christmas present for all of us interested in this to read from the agency. And I will say that Gina McCarthy had given a prediction that this was coming in January of 2011 when she announced to the electric utility industry that basically EPA was going to promulgate a series of rules that would require scrubbers and NOx controls, and the industry should be getting ready for it, and we see that she's fulfilled that promise. Just a short bit of background on the rule, that this has been a long time in the making, from the Clinton era decision to regulate electric utilities to the Bush era when we had the Clean Air Mercury rule, or CAMR, that came out and had a number of more aggressive concepts in the sense of how you would interpret the rule, and then those concepts were thrown out in a court decision that was issued in 2008 and basically said that the agency has to go back and promulgate these kind of MAC standards consistent with how the MAC statute was written in the Clean Air Act. What we have now is an Obama-era rule where clearly there was interest in trying to build a record to support this in the event of the eventual challenges. They've gone a traditional MACT approach of top performers and then on the floor, and then the timeline for the rule work is set out below that. I'm going to turn over to Dottie because some of the interesting parts of this rule really has to do with marketing of it and how we're seeing that maybe it's election year politics or whatever, but it's a very unique form of trying to sell this rule to the general public as an acceptable form of regulation. Dottie?
Right, Mark. It's actually been unique in the world of air regulation, that's for sure. EPA's come out with not only kind of the technical website to give us information about what's going on with this rule, but have developed a public access website that's supposed to be very user-friendly, highlighting health impacts from this rulemaking, and in a lot of ways just trying to do a good PR campaign on negative press that could be coming out from the other side, particularly as it relates to things like job creation and cost to the industry. It's been pretty interesting. There have been, over the few days after this rule was released, there were numerous press releases done by various people, both on the political side and in the general public, about the positive impact of this. They're trying to spin it as being a huge boost to children's health. So actually they did an announcement at the Children's Hospital Colorado trying to highlight positive impacts to asthma, for asthma in children. And one of the more interesting things is that there's a video on YouTube featuring former halfback for the Pittsburgh Steelers, Jerome Bettis, again, who's a pretty outspoken asthma advocate, talking about the positive effects of this rulemaking. So that's a pretty interesting thing coming out of it. Again, a lot of this deals with how the EPA is trying to frame it to the public. It's not clear right now whether this is just, good PR, again, election year type thing, or whether it's possibly to stave off potential challenges to the rule down the road, given the history of what it took to get us to this point. But interesting nonetheless, and something worth poking around at if you're interested. Again, Mark kind of said the rule was really developed by the book. The agency went through the process pretty thoroughly in coming out with this rule after the predecessor rule was thrown out. It does take a pollutant by pollutant approach. They did look at best achievable levels for each pollutant and not on a facility-wide basis, which is something that a lot of the chatter is dealing with right now. And the really big difference from the predecessor rule is that this only allows, it doesn't allow for fleet-wide averaging. It's really facility and substation-specific averaging. So that's one of the challenges that everyone will be facing in implementing this rule.
What we want to cover. Oh, go ahead.
No, go ahead, Mark.
What we want to try and cover is a couple of the high points of some of the changes from the proposed rule, and a couple of things to watch for in the actual rule as you go through. And some of them apply to other MAC standards. So even if you're not in the electric utility business and in other industries, you might want to take a look at how they frame some of these kinds of concepts in the rule. One of the interesting parts that's been out there is some of the definitions in terms of coal-fired, and they separated out a new definition for natural gas-fired. But then they come into cogeneration, which over the years has been an interesting series of definitions of what is a cogeneration facility, which in the earlier frame of the Clean Air Act rules had been difficult to decipher as to whether you were cogeneration or not. For purposes of EGU, they've got the 1/3 of generation being sold to the grid and greater than 25 megawatts. You're under the EGU MACT. If you fall below that, then you're under the Boiler MACT, and you can swing back and forth under EGU and under Boiler MACT. Obviously, that creates quite a bit of record keeping and compliance issues to swing back and forth between two different MACT standards. And then if you burn solid waste and you're under SISWI and you fall into SISWI, you can't opt out of SISWI. So you've got to figure out in this code generation world what you want to be and which rules will apply to you and keep track of that. They did some subcategorization with respect to fuel and basically a BTU classification. This was discussed quite a bit in the preamble because it's one of the first times they've done subcategorization, not on process type, but on fuel being burned. And we've got some surrogates for the non-mercury HAP being proposed, change from a total particulate to a filterable particulate, and the use of continuous monitoring systems for measuring the non-mercury HAPs. One of the things that seems to be quite common in these MAC standards that's evolving is the workaround to numerical standards. As I recall, the MAC has to apply during all of the conditions that a unit is operating after the exemptions for startup, shutdown, and malfunction was thrown out by the court. So now we need to have a MAC standard, and as opposed to numerical standards, we're coming up with work practice approaches. And similar to what you see in a number of BAC type approaches, the MAC here is talking about inspecting, tuning, optimizing, maintaining records of work that's done. And one of the things that will be important for MAC compliance is maintaining those records. They move from tune-up requirements from an 18-month cycle to 36 months, which is consistent with a number of the changes in the electric utility industry where shutdowns and major overhauls are being extended. And then they have something in the rule, and maybe those in the EGU world know what a neural network system is, but it conjures up some interesting thoughts of being plugged into somebody's brain. But if you do have a neural network, you get a 4-year cycle instead of 36 months. One of the things to watch out for on a work practice standard is manufacturer specifications, and this appears in a lot of air codes and a lot of systems where you're to follow manufacturer specifications on what to do to maintain the equipment. One of the first times this rule allows you to apply those specifications to the extent applicable, but you need to really document the extent applicable. So if you change from the manufacturer's specs, make sure that you have a rationale as to why the change is there and you document what you're doing. A couple of other key components in the rule. We do now have a specific definition of when startup ends and shutdown begins. Remember that startup and shutdown conditions are handled by the work practice, and then the numbers start kicking in when the startup ends or the shutdown begins is when you would go under the work practice. So these may be definitions you'll see in other permitting contexts, such as possible future backed permits in industry for fuel burning equipment, so you might want to take a look at this. Other thing is during startup and shutdown, all controls except for dry scrubbers and SCRs are to be on when coal is being fired, and the scrubbers and SCRs are to be on when conditions allow and must operate. So again, an important item for record keeping. They did exclude the startup and shutdown days from the 30-day rolling average calculation, but of course then you need to define what is a day and make sure you understand what falls within the definition. Couple things on malfunction. Malfunctions are not excluded from the rolling average calculations, and either have enforcement discretion with respect to a malfunction or you have an affirmative defense coming up. The interesting part is the affirmative defense context was borrowed from the wastewater treatment plant context, and the burdens on the permittee in those cases and in this case to show that it was sudden, infrequent, repairs were quickly done and emissions minimized. And you may want to consider a malfunction plan to justify this affirmative defense if you're going to rely on it, because the burden will be on the company to show that it actually occurred. Just briefly, a couple things on monitoring. There certainly is the preference for CEMs or continuous parametric monitoring, because otherwise you're doing quarterly tests, which can mount up in costs and complexity. Dottie mentioned there is some emission averaging, but it's very tight. It only applies to existing sources, same category, same facility, and averaging needs to be based on tests. One of the concepts here is that obviously as monitoring becomes more rigorous, it really has the effect of making the limits more stringent because there's less room for error to occur, and we're tightening down on these standards. Compliance, typical for MAC. The atypical part is that if you're able to show for cause and reliability concerns, you can get it extended for another year. As with all of these, there's a lot of controversy in the industry. There was a lot of counter reports on electrical reliability, would the lights be on or off, or brown or black, and there's even disagreements in the industry about the rule. Those who are heavily nuclear were in favor of the rule. Those who were heavily coal-based were not. There was an effort by the White House to avoid a rule challenge by the utility industry, and that does not seem to have been accomplished. So challenges probably likely to occur, as they do with almost all of these MAC rules that have been coming out. Likelihood on the challenge, as Dottie mentioned, there's a very large record to support this rule, and they took a very conservative statutory approach for defining limits in terms of process. So there may be technical issues with it, but we don't have the large issue as was the case with Cameron, where there was a different interpretation of the Clean Air Act at play. So we may have challenges, but the likelihood of the entire rule being thrown out is less given the approach that EPA took. And with that, I will turn it over to Dick then to talk about another one of the developments we've had.
Okay, thanks, guys. And Mark was closing there with the likelihood of overturning that rule in the D.C. Circuit. I will say that we have some good news later on for the electric utility people, at least with respect to the cross-state. Brian's going to get to that in a few minutes. Sometimes the D.C. Circuit does throw things out, and sometimes the D.C. Circuit will even state them pending review. We're going to get to that after we go through some of this CISWE and Boiler Max stuff. Also, to segue from what Mark and Dottie were talking about, everything they were talking about affected only EGUs. When Brian talks about the cross-state rule, that's only EGUs. But now we're going to talk about other industry for a while and the impacts on other industry. Now, EGUs could be affected by CISWE if they burn non-hazardous secondary materials. And I guess, as Mark was saying, smaller EGUs might actually be affected by these Boiler Mac rules. But the EGUs won't be affected, except in those circumstances, by the next few slides. Okay, it's going to be much of the rest of the industry. Okay, so remember now, when we talk about CISWE and Boiler Mac and the non-hazardous secondary material rule, remember about a year ago, EPA, under incredible rush rules, they had asked, they were subject to a citizen suit deadline here in the District Court and District of Columbia. They decided that they needed 15 more months to do the rule right. The Sierra Club objected to that and gave them 1 month instead of 15 months. So they started to issue these final rules that everybody now knows, including EPA, were basically just a mess, just a total mess. Unlike, I think, the top people at EPA now who seem to relish in putting major costs on electric generating units and do so with, the $10 billion a year rule that Mark and Dottie were just talking about, EPA did not necessarily relish going final with these Boiler Mac and CISWE rules. In fact, in the 2 or 3 months before they had to finalize them, there was tremendous pressure on the Hill and in public opinion all over the place about EPA having to do something to relax on their approach for Boiler Mac and CISWE, because they were going to put, small businesses at great risk and all that kind of stuff, and jobs and unions and everybody were going after them. So even with the great fanfare for the EGU rule that Dottie was talking about, where EPA has its own press page now and does press releases, regularly about how great the rules were, EPA was actually preparing people before they issued these rules back in February of 2011. And I say, well, don't worry, because once we issue them, we're going to reconsider them and stay them and all that kind of stuff. And sure enough, they did. So just to set the framework for what we're talking about, remember we have the CISWE units under CAA 129. We have the Boiler Macs under 112. And tying this all together is this RCRA rule for non-hazardous secondary materials that would define what is a solid waste when combusted. And if you are then a unit that combusts what's defined as a solid waste, you're SISWI. And then if you're burning something that's not defined as a solid waste, then you're not SISWI. You're either boiler MACT or you're Portland Cement MACT or whatever. You're something else. I should say right now off the bat that early on, the way the SISWI rules came out, and here's where they, in the Federal Register of March 21st, most people were assuming that SISWI equaled death, and nobody wanted to be a SISWI, and that every effort was made by industry to get more and more materials out of the definition of solid waste because everybody viewed the SISWI standards as being close to impossible to meet and driving people out of business, which is a fair assumption based on prior rules that EPA had issued under Clean Air Act 129. So just, again, EPA announced the day they issued these rules, they announced they were going to reconsider them because they knew doggone well that there were too many gaps. There was a great lack of data to support almost everything they were doing, and they knew that they would get beaten badly in the D.C. Circuit on that record, and there was tremendous political pressure for them to do something here from just, and not just Republicans in Congress, but also a lot of Democrats. So to set the legal stage a little bit, as soon as they issued the rules, they did announce a reconsideration. As usual, all industry and environmental groups came in and filed administrative petitions for reconsideration. They filed D.C. Circuit petitions for review. That's, typical stuff. And then not only did EPA announce a reconsideration, but soon after that, in May, they announced an indefinite stay of the effective date for both the SISWI rules and the Boiler MACT rules, and that's in the May 18th Federal Register there. I should note here that at that point, EPA did not make clear, and in fact, they refused on questions to make clear whether that was going to roll the 3-year compliance date for Boiler MACT or the 5-year compliance date for SISWI forward. Everybody said it's great that you're extending the effective, you're delaying the effective date, but the effective date is just the date that the rules actually become, sort of legally on the books and stuff like that. But the key question is the compliance dates, and EPA refused early on to answer that question. So EPA goes to the D.C. Circuit where the judicial review was being held, and basically says, hey, we've stayed these rules. There's no point, and we're going to change them. There's no point in doing any judicial review now. Industry didn't object to that, but the Sierra Club did. The Sierra Club, they're the ones who'd gotten that court order that forced EPA to issue those rushed regulations way before they were ready for prime time. And the Sierra Club filed strong objections to this motion by EPA and basically came back and said, no, the EPA just can't stay these things indefinitely. And so Sierra Club actually petitioned the D.C. Circuit to reverse that stay, and they also went back to the district court, to the very judge where they had gotten their order that forced the regulations out, and filed a proceeding there to try to get EPA's stay of those rules reversed. And we talked about that a little bit in a prior web conference. Now, in fact, this slide actually comes from a prior web conference, and we were sort of telling you what would happen if Sierra Club prevailed. And by the way, listen carefully because we're going to tell you pretty soon that they did prevail. So, if Sierra Club prevailed in their motion before the Federal District Court to reverse EPA stay, there's some consequences there. And particularly for new, of course, everybody says, no, wait a minute, the Boiler MACT rules don't go into effect for 3 years for existing sources, and they don't go into effect for 5 years for SISWI, so, what's the big deal if the stay is lifted? Well, at least for SISWI, you have major concerns that you could trip into new source status by doing any kind of change at your facility. And when people have asked EPA in the past what kind of changes might trigger new source standards, EPA has not given the answers yet. So you can be at peril if you're an existing SISWI source, that is, if you're burning something that's been defined as a solid waste. And if that stay were lifted, then you're subject to citizen enforcement or EPA enforcement if you do certain things that's later deemed to have triggered new source standards. And by the way, those new source standards are virtually impossible to meet. So anyway, going to the next slide here. We'll get to what happened on Monday in a minute, but in the meantime, EPA did go ahead, and as they said they were going to do, they've developed some fairly major reproposals to the SISWE and Boiler Act and the RCRA non-hazardous secondary material rules. And those did come into the Federal Register just on December 23rd. And there's your Federal Register sites. This time there's just one Federal Register notice combining SISWE and non-hazardous secondary material. And then there's a separate Federal Register notice for Boiler Act, which Brian is going to talk about in just a couple of minutes. There's actually a different one for major sources and area sources of boilers. February 21st is the deadline for filing comments. I have heard that some people are going to request an extension to the comment period. Some people think it's unlikely that EPA is going to be willing to do much of an extension on the public comment period, primarily because in defending against Sierra Club's efforts to get their stay reversed in the Federal District Court here, EPA went ahead and committed to a fairly rapid schedule. And the fairly rapid schedule that they committed to, and they told the court, they told the D.C. Circuit this, and they told the District Court this, was that they were going to propose these changes to the SISWE and Boiler Act rules by October of 2011 and then finalized by 2012. Of course, we know they missed the October proposal date already. They missed that by a good month. And nobody I know think there's any way possible that EPA could finalize these rules by April 2012. There's just too much going on, but in any event, they're going to be under the gun, and I think they're going to feel under the gun to do it as quickly as possible. So because of that, there may be not a great likelihood that they're going to grant much of an extension of the public comment period. But okay, so we had prepared you before in a prior web conference to sort of be alert as to what might happen if Sierra Club prevailed and got Judge Friedman to vacate EPA's stay of those rules. Well, guess what? January 9th, Monday, Judge Friedman issues a 45-page opinion, and he vacated EPA's delay notice. So when EPA, going back to May now of 2011, when EPA said, hey, we're reconsidering SISWE and Boiler Act, since we're reconsidering them, we're going to repropose changes. We don't think, therefore, that these standards right now that are on the books, that obviously the rules are flawed. We don't think they ought to be in place and force. We delay them. Judge Friedman reversed that, and the reversal, in effect, puts them back into place. So right now, as of today, what I think most people would totally agree, and I think EPA people would too, those very flawed SISWE and Boiler Act rules are legally effective. So you might want to get out your March 21st Federal Register again and start looking through them, because that's what's there now. Again, for people saying, well, wait a minute, SISWE has 5 years and Boiler Act has 3 years. Again, at least for SISWE, you got to worry, because all of a sudden you're vulnerable for possibly triggering new source status. Also, what about boilers? I've heard that some boilers actually have commenced construction in the last few months, and they're all of a sudden, under the theory that there were no Boiler Act rules in place, are they now new sources? I've also heard, and I'm not an expert on the Boiler Act rules, that there are certain notification provisions that have come and gone, but people thought that the rules were not effective, so they didn't do them. Now what do you do? Because the rules are back in effect. Now, it's unclear now whether EPA will appeal that judge's ruling or whether the industry interveners will appeal that judge's ruling. There's a 60-day period in which people can decide. But I will say that right now, and based on calls I've had with industry and so forth, the main two words now are mass confusion. It's just mass confusion as to what is really going to happen now and what totally is the effect of his ruling, but it's there. For instance, one thing that doesn't get clear from his opinion, and it's not clear what the effect of his opinion would be, whether now EPA, by the way, EPA has proposed, I was going to get to that just for a quick minute, EPA has proposed in this latest SISWE and Boiler Act rulemaking that went to the Federal Register on December 23rd, they finally answered the question they wouldn't answer before, and they have proposed to roll out that 3-year period and the 5-year period from the date of the new final rule. So whereas originally, say, the SISWE deadline would have been 2016, under the new theory, if SISWE was going to go final again in July of 2012, then the new SISWE deadline for existing sources would be July 2017. There's stuff in Judge Friedman's opinion that really calls that into question. Again, it's not clear. Nobody knows the answer for sure. When you have time to read these slides later, there's the section of his opinion that I would say if the D.C. Circuit doesn't reverse that, and they might not, there's a good argument the Sierra would have that EPA cannot go beyond the 5 years from 2011 for CISWE, and EPA cannot go beyond the 3 years from 2011 for Boiler Act. Again, I would argue the contrary, and I could probably write a pretty good brief to the contrary, but it's pretty much up in the air. I wouldn't want to rely on Judge Friedman's opinion if I were writing that brief. A few key points to note on these new reproposals. On the non-hazardous secondary material, let me just give you one real bottom line on non-hazardous secondary material. For a lot of industry, including pulp and paper and some other industry, EPA actually got a lot more liberal in this reproposal in a manner that is going to allow a lot more materials out of the definition of solid waste. So for many industries, this new proposal represents quite an improvement. For some industries like Portland Cement that was very interested in things like landfill tires, for instance, there is no improvement. But for large segments of the industry, there is great improvement. Improvement meaning that less stuff is solid waste under this new proposal that EPA just published on December 23rd. A lot of the focus is on biomass, and EPA really liberalized a lot of stuff on biomass. Also, if you're familiar with this rule, one key factor in this new rule was the so-called legitimacy criteria, and everybody was having major problems with the legitimacy criteria. EPA has greatly liberalized in this proposal the way it would apply the legitimacy criteria. There were some questions, for instance, with respect to tires and established programs. There was some question whether they could meet the legitimacy criteria, and people were worried about all the time and effort it would take to make those showings. EPA took care of those people real good here. They just basically exempted them from the rule totally. So if you're a tire coming through an established program, and now I'm not talking about landfill tires, but tires coming through established program, and also if you're resonated wood, I'm not sure exactly what that means, then you're just totally exempt. Those are special exemptions that go right in the rule, and EPA just took them out. They also solicit comments on other things that they might put into this so-called national exemption, and they did mention manure, and they didn't distinguish among animals. They also do state an intent to make their case-by-case petitions for non-waste much easier than people had thought. But again, and this is bad for the Portland cement industry on this last one, that there's certain materials that have been discarded, like landfill tires, and there was a very aggressive definition of processing in the final rule of March, and that has not been changed. EPA has been unwilling to change its approach on that. On CISWE, the changes, again, as I said, the bottom line to the non-hazardous secondary material rule proposal is to be actually kinder to industry for the most part. I think so far from what I'm hearing from our technical people that I talk to is the same on CISWE. Bottom line is, on the third dot there, is apparently some of the emission limits now, and I'm not necessarily this applies to boilers, but it certainly does for cement kilns as I understand it, that the standards are somewhat kinder and gentler than they used to be. And one thing I'm also hearing from various quarters in the industry is that even though everybody thought CISWE was death back in March, that nobody ever wanted to be a CISWE unit unless they couldn't find any way out. I'm hearing that that's not necessarily the case now with this new, with the new proposal. The new proposal does seem to be somewhat more palatable, at least in some industries, than the March rule. They did, again, the first dot here, they answered the question that they had refused to answer early, and the proposal says they will go out 5 years from the new final rule, but that's called into question somewhat by Judge Friedman's ruling of this Monday. And that's certainly, there's some new arguments that Sierra can make, at least, that EPA can't let that 5-year period roll. Here's another important point for some industries, the second point here. There had been a major snafu on what's contained gas and what's not, and I know this affects steel, and affects some cement, and it affects various, I know it affects the American Petroleum Institute in a big way. EPA had for years ruled that gas going through a pipe was not containing gaseous material, and if it's not, then it's not a solid waste. And then to surprise everybody in the final rule in March, they reversed themselves on that. And a lot of industry just went wild on that. And I think so here's one other respect where EPA went back and did something rational in this proposal and has gone back to their old way and well-established way of defining contained gaseous material in a way that basically takes gas that's going through a pipe on its way to being combusted. That gas is not a solid waste. There's an interesting scheme that's being proposed in the SISWI rule for how you can go in and out of SISWI status if there's a period when you are burning solid waste and you're not burning solid waste, so you can go back and forth into either Boiler MACT or Portland Cement MACT or whatever. Unfortunately, though, and a lot of people have been very concerned about this, there are major ambiguities right now as to how an existing SISWI source might trigger new source status. A lot of industry had filed extensive comments with EPA on the first round of rulemaking saying, you've got to clarify this, please clarify these issues. EPA didn't do a doggone thing about that in the final rule in March. And unfortunately, in this new proposal, they don't do a doggone thing about it. For your reading later from the PowerPoint, because I'm going to turn this over to Brian in just a couple seconds, there's EPA's own summary summarizes some of the changes, and a lot of them are quite technical on SISWI. So there's several slides in a row here that I just took from an EPA summary sheet. You can read the PowerPoint later if you're interested. Most of them are quite technical. And again, the February 21st comment deadline ought to be taken fairly seriously, I think. Okay, Brian?
Thanks, Dick. As Dick said, I'm going to cover the new proposed Boiler MAC rules, which were proposed in December. Judge Friedman's stay decision and how that affects Boiler MAC. Dick has already talked about it in the SISWI context. And then I'm going to finish up with the cross-state rule stay that the D.C. Circuit issued, what is now a couple weeks ago. We've done webinars in the past on both the Boiler MAC and the cross-state rules, which are available on Foley's website. So I'm going to try to focus today on the changes that have occurred since our past webinars. Starting with the Boiler MAC, as Dick mentioned, the Boiler MAC rule, the final Boiler MAC rule was announced in February of 2011, and it's sort of progressively gotten better for industry. The first proposal EPA came out with was really stringent. The final rule that they came out with in February was slightly less stringent, although there was still backlash. At the same time they issued that final rule, EPA admitted there were problems with it, again, given the court deadlines and the haste with which they had to put it together. And so they announced they were going to reconsider the rule when they issued the final rule. And the December rule, which I'm going to focus on today, the proposed rule, is again slightly less stringent than the final rule that was announced in February. Even so, the final rule, EPA stayed that rule in May, and that's the stay that Judge Friedman lifted in his order just on Monday. So today, if you're subject to the Boiler MAC or worried about the Boiler MAC, you're in the odd position of having final rules in February that are technically effective, even though EPA said they don't want them to be effective. And at the same time, looking at a proposed rule, which is pretty significantly different than that final rule, and expecting new final rules on reconsideration in the spring of 2012, around April is the date, although it could be sooner given the stay, that the stay was lifted. So the Boiler MAC, if the proposal doesn't really change the sources that are affected in any significant way, it's all existing industrial, commercial, and institutional boilers and process heaters within a subcategory, and there's a list in the rule of subcategories that are located at a major source and that do not combust solid waste. It also includes new or reconstructed boilers that fit that definition. The standards proposed change slightly. They're based on, as with any MAC standard, the best 12% of existing and the best of the best for new sources. EPA's proposed limits for total selected metals or particulate matter, hydrochloride, mercury, CO, and dioxin furans. The limits are all available, and this is really the guts of the rule. On pages 19 through 23 of the proposal, there's a table that lists by subcategory what limits you have to meet if you're in that subcategory. Now, if you're less than 10 million BTU per hour, if you're a less than 10 million BTU per hour boiler, you do not have to meet the emission limits in the table. If you're greater than 10 million BTU per hour, then you do. So the main changes from the proposed rule, which just came out in December, and the final rule, which is effective but was issued in February, there are now optional output-based standards rather than for some subcategories. There are now work practice standards rather than numerical emission limits for smaller existing boilers, gas 1 subcategory boilers, limited use units, and some others. One of the big give-backs to industry in the proposed rule was there was a lot of backlash about the dioxin furan emission limits in the final rule and in the very first proposed rule. And EPA backed down from that and has now proposed work practice standards instead of emission limits for the dioxin furans from all subcategories. And like the final rule, the proposed rule still has the requirement that all existing effective boilers and process heaters have to do a one-time energy assessment to identify cost-effective conservation measures. And that's beyond the max floor. So one of the other big areas where there were some significant changes from the proposed rule in December and the final rule is that under the final rule, the emission limits applied during all startup, shutdown, and malfunction periods. Under the proposed rule for malfunction the malfunction provisions don't change. The limits still apply during malfunctions. But for startup and shutdown, the numerical limits no longer apply, and they've proposed work practice standards. So similar to the EGU MAC that Mark talked about as far as startup and shutdown, they have defined startup as going from 0 to 25% load, and shutdown is 25% load down to no combustion. And I've listed here some of the work practice standards. As far as the testing and initial compliance, all new and existing sources are going to have to perform or conduct performance tests to demonstrate compliance. Generally, an initial one when the rules go into effect, and then an annual one going into the future. The tests, as they do in most cases, you'll have to take operating parameters from the test and put them in your permit. If you're a boiler smaller than 10 million BTU, you get work practice standards and don't have to do testing. So again, this is similar to CISWE as far as the compliance dates go. The Boiler MAC compliance date in the final rule, which is now in effect, was the final 3 years from that final rule, which was issued in February 2011. So that would mean that the Boiler MAC standards would apply February of 2014. EPA basically pushed that back a little more than a year and says that for existing sources, they don't have to meet the standards until 3 years from the final reconsideration rule, which at this point is slated for April of 2012. New sources have to meet the standards within 60 days after date of publication of the final reconsideration rule, and they have to meet them at startup. And to determine whether or not you're a new or existing source, the cutoff date is June 4th, 2010. There are also a number of quote-unquote technical corrections in the rule, which were EPA described as basically fixing factual errors. So the Boiler MAC, as I said, it's gotten progressively less stringent in each iteration, but it's still very controversial. EPA is accepting comments. I think the comments are due February 21st on the Boiler MAC, just like CISWE. The industry is still supporting a House bill to delay the Boiler MAC standards by roughly 3 additional years. The Senate has also considered a bill, and President Obama has threatened to veto the bills. The final rule, as I said, is slated for the spring of 2012, and as with any rule, we're likely to see challenges. The Friedman order has now put into effect the February rules, at least for the time being. And for the Boiler Act, that is a little bit less worrisome than CISWE in that you don't have to, existing sources don't have the same worry of triggering the new source requirements as you do under CISWE. However, it does apply to any new boiler, and it would also, there, as Dick mentioned, also maybe some reporting or other requirements that have already passed or are upcoming that could be affected. So it's something you should definitely be aware of and be looking into. So turning to the cross-state rule, this was a big win for industry 2 weeks ago. The cross-state rule, for those of you that don't know, replaced the Clean Air Interstate rule. The D.C. Circuit overturned the Clean Air Interstate rule in its North Carolina decision. The cross-state rule created 3 programs: an SO2 annual program, an annual NOx program, and an ozone season NOx program. And these are allowance trading programs. There was 2 phases of compliance, and the final cross-state rule came out in the middle of 2011, I think July. And the first compliance date was January 1, 2012, so 6 months later. And as you know, as you've seen through the rules we've talked about, most EPA rules don't go into effect for at least 3 years. So there was a large outcry from industry focused on the compliance date, and frankly lots of errors in EPA's rule, both legally and factually. And so that led to 45 petitions for review in the D.C. Circuit challenging the rule, and 19 stay motions that were filed asking the D.C. Circuit to stay the rule pending review. I think we have estimated in the past, and the numbers I've heard are less than 5% of EPA rules end up getting a stay pending review. So the fact that the court granted the stay here is a big deal. This also was probably, from what from most folks have told me, that this was the most stay motions they'd ever seen in an EPA challenge before in the D.C. Circuit. So the backlash was significant on the industry side. What does the stay mean? It doesn't say anything about when the cross-state rule would come back into effect if the court upheld it. It just says that it's staying. The court order says that the cross-state rule is stayed and that CARE is in place for the time being. The court order asked for arguments in April, which is a really fast turnaround for a number of reasons. To get all the briefs filed and have arguments by April is going to be a huge effort, given the coordination that has to happen between all the petitioners and the sheer number of legal arguments that are at issue. I think I've seen lists of legal arguments, and there are at least 40 different arguments raised by all the parties. Obviously, there is some overlap. So one of the big questions that came out immediately is, what's going to happen? Does this mean that we don't have to comply with the cross-state rule in 2012 at all, or is it possible that the cross-state rule might be reinstated for part of 2012? The general consensus is, for a number of reasons, is that the cross-state rule will not apply at all in 2012. So the earliest it would likely apply would be January 1, 2013, but then there's questions about, well, what's EPA going to do? Are they going to still have a 2-year first phase, which would be 2013 and 2014, with the second phase kicking in 2015, or would they keep the rule as it is now, so the first phase would only be 1 year in 2013, and then the sort of ratchet would go, the allowances would be ratcheted down in 2014. And that covers the cross-state stay. I'll turn it back over to Dick to wrap things up.
Okay, and can I just ask our operator, do we have any Q&A that's come in by email, or do you now want to throw it open for questions by phone?
Ladies and gentlemen, if you have a question at this time, please press the star, then the 1 key on your touch-tone telephone. If your question has been answered or you wish to remove yourself from the queue, please press the pound key. Once again, if you have a question at this time, please press the star, then the 1 key on your touch-tone telephone. I'm not showing any question at this time, sir.
Okay, well, I have a feeling maybe this is all a little overwhelming considering how fast things have been happening in just the last few weeks. But in any event, hopefully people will be able to read through the PowerPoint and any questions they might have will be answered by the PowerPoints and or by referring directly to EPA's rules, although, again, I guess one common theme is, particularly after Judge Friedman's order of Monday, is that there will be just a great deal of confusion about at least the SISWI and Boiler Act rules now, and the fact that they're back into effect even though there are proposals out there to change them. And that confusion is not likely to be lifted anytime soon. Please realize, thank you for coming, by the way, please realize that the PowerPoint and the audio will be available on our website soon. There's the link that would get you to it. If you have any CLE questions, please email Jen Bartz, and there's her email address. And if you have just a couple of minutes, we always appreciate it, and we thank those. There's a group of people who always seem to do this, but we definitely appreciate the feedback. The feedback, you know, there's the survey right there. It takes you about 1 minute or 2 minutes, and we would ask that you do that because that also gives us ideas for how we can improve for next time. So thank you again for coming.
Ladies and gentlemen, thank you for participating in today's conference. This concludes the program. You may now disconnect.